and this maybe be a good bridge. The guy who was talking about this at the time and said it was coming is now bringing a case up before the U.S. Supreme Court because judges are trying to use their power over litigants to suppress, censor, and punish speech.
So let's do this. We shall refer to him as AJ tonight. And I saw someone in the comment section said, nope, I knew about all of this because I was watching his channel. Not his channel, but rather his platform. Jones has filed a petition for cert. Now, I'll try to summarize it because it's tough for me catching up on something that I haven't been following from the beginning. He's being sued for defamation. It's in Connecticut.
A bunch of cases. And I have some tangential role in that because I was his counsel for a period of time. And so, as full disclosure, so that's why I know what everything related to the case.
Well, and now my own
sued on a bunch of different theories related to statements he made or was alleged to have made concerning an event at a town in Connecticut. Another terms to stay away from because to get flags everything. But but basically what happens is he gets sent spam that has illegal material in it. As part, he never opens it. It's sent to his broadcasting platform. The part of the discovery that's issued in the case is, in my view, crazy, unprecedented, unparalleled.
So actually, just stop right there. Is the discovery, from what I understood, was in the context of an anti-SLAPP motion?
Yes. For an anti-SLAPP motion, more discovery than has ever been ordered in the history of anti-SLAPP statutes.
And this is the context where I just, coming into it, it's like, what the heck is going on? He's being sued for defamation. Connecticut has anti-SLAPP legislation, meaning if you're being sued for exercising a constitutional free speech issue, you can make a motion to dismiss on the basis that it is a strategic lawsuit against public participation. You can invoke the anti-SLAPP statutes. And then the onus goes on the plaintiff to show that they, basically to show that they have grounds to sue and that it's not a protected right. In the context of Jones' anti-SLAPP motion, they order discovery, and from the petition for cert, extensive discovery, it looks like. So that I understand.
Unprecedented. Basically, he ends up having to turn over everything that's ever been sent to him for years, for like 7-8 years. And so he didn't know 90% of what's in there because it's spam stuff that no one had ever looked at. In there was illegal material that someone had tried to deliberately plant on his servers. The FBI acknowledged that he was the victim of this, but the plaintiff's lawyers use it. And because whatever you file in court, you're immune from suit on. So they get to say things in court they could not say without facing lawsuit otherwise. The media then deliberately misinterprets it and spreads one of the craziest lies about him that's ever been spread. And this is a guy who's had a lot of lies spread about him. A lot of people think they know things about him that they do not know, that they think things are true that are not true about him. There's a lot of things you can criticize him for, but 90% of what people criticize him for, he didn't do or didn't say. So this naturally agitates him. On his show, he's trying to respond to this onslaught, this massive libel against him, and voices his dislike and in some choice words about the plaintiff's lawyer in the case. All of a sudden, the court rushes in, considers dismiss. I mean, I think it was within a day or two. So much for due process, and considers dismissing and granting a judgment against him on all claims without him being able to defend himself at all. Backs off from that cliff and instead says, well, I'm just going to not allow you to do any of your anti-SLAPP defense because I don't like what you said. And that goes up to the Connecticut Supreme Court. They take a while to rule on it. They determine it's now okay. And the problem is, here's what the new rule is. If somebody sues you, they can take away your free speech now. Because somehow just the fact that they've sued you means you no longer have First Amendment rights anymore if it relates at all to the suit, which is not. This goes right back to the 1940s, Bridges versus California. So a labor leader, and it was joined with a newspaper case. A labor leader, Harry Bridges, who would get involved in a lot of legal controversy because he was probably a communist. There was tons of stuff. He had like 3 or 4 cases go to the U.S. Supreme Court. He'd be my kind of client, always in trouble, but for the right reason. But what happened is a state court, a judge came in and said, not going to allow him to strike and do some other labor activities. He tells the secretary, somebody in FDR's cabinet, if anybody tries to enforce this judge's order, we're guaranteed to strike. Of course, the judge is enraged. What are you doing saying that you're going to challenge my order in that manner? And holds him in contempt of court and wants to send him to jail. That goes up to the U.S. Supreme Court, and the U.S. Supreme Court made clear courts are state actors like anybody else. Just because somebody's a party to your case, you have no more right to violate their First Amendment than any other state actor. And you have to have extremely emergency and extremely imminent circumstances. Great decision written by Justice Hugo Black, named after Victor Hugo, the great French writer, Les Miserables, Les Mis, and says, and the Supreme Court decision makes clear you can't do that. They also joined it to a case where the editorial page of a big newspaper was trying to put pressure on a judge to sentence certain people. And again, the court said, you cannot punish the newspaper either. That it has to be, so like even gag orders are mostly, the reason why you don't see them is they're mostly unconstitutional because they're a prior restraint.
Well, and that's exactly what I was going to bring up is the Roger Stone gag order. No, Michael Flynn did not have a gag order. But now the question is this, from what I understood from the petition for cert, AJ did not have a gag order in effect, correct?
No, there was no prior restraint, no prior notice. He wasn't even given meaningful opportunity to be heard on this issue. And again, the people make much worse statements about lawyers every day within earshot of the courthouse, usually in the courthouse. At least a third of the time, they're saying it to me from the other side. So I've never said, "Oh my goodness, judge, put him in contempt, put him in jail." Now I've had opposing lawyers try to hold me in contempt, just for whatever excuse they want. But it's an easy misused and abused source of power, and everybody knows it's a dangerous particular tool of courts to misuse and abuse that power under their inherent authority. And they said even if the statement could be reliably and inherently determined to bring doubts on the court or even a court's order, it is not constitutional for the court to punish, to do anything to an individual simply because they're a party to the case in consequence. It's got to be in the courtroom. It's got to be, again, extreme emergency and extremely imminent criminal conduct. This didn't come close to meeting either of the two. So now the big question is, will the Supreme Court take a case with his name on it? Because the whole legal system doesn't want to apply the same rules just because they don't like him. But that's exactly who we need the First Amendment for. You don't need the First Amendment for popular speech.
Well, I was going to say, on the one hand, AJ Jones is the modern day Larry Flynt. I mean, if anybody, I think he's less. I don't know if you've seen the deposition of Larry Flynt, you might have different views of their demeanor, but the modern day equivalent.
Larry took it. That would have been a fun deposition to review in live time. Larry Flynt, or Joe Francis. Oh man, there's some people. But he is politically, his politics are disliked by the establishment, and they hate him to a large degree, in my view, often for ill-justified reasons. But putting that aside, this is if we open the door to allow courts to say, as soon as somebody sues you, we're going to strip you of your First Amendment rights, even if you're a prominent broadcaster, under the pretext that, heck, you've been sued. So now you have no more any rights relating to that case in any way, shape, or form. Where he didn't, like, those statements in Bridges were about the judges. He wasn't talking about the judges. He was talking about the opposing lawyer. You now can't criticize the opposing lawyer, without potential contempt. This is political abuse of the judicial process.
We saw what happened in the Colthage case, where when they were told, they can't make certain public statements about a pending case. This is civil and not even criminal, if that makes any difference. But is the risk not? I'm reading this, and I'm just trying to appreciate from a precedential value. Is the Supreme Court not going to look at this and say this is too specific to one person? There's no broader application. There's no broader importance or meaning. So we're going to not even consider cert, because it's basically one person's problem with no broader impact.
The interest is really broad, because now it's a Connecticut Supreme Court decision that says there's a new exception to the First Amendment, and that if you're a litigant to the proceeding, courts can do whatever they want to you if the speech relates to that, regardless of the First Amendment. And that no court has ever done this before. And the only thing that got close to it was the Bridges case. And if the Supreme Court's going to continue to enforce the Bridges decision, then it has to take this case. But we'll see. But and again, credit to AJ for being willing to take these, because these are expensive petitions. I didn't file this petition, other lawyers did. But, this is difficult, expensive work that he's been willing to do because it defends and represents a much broader cause than him personally. He could survive this particular order. He took this up in order to defend the First Amendment writ large. He's actually like a less controversial version of Larry Flynt. Well, what Larry Flynt was fighting for the First Amendment, AJ is now.
The question I was going to ask, the Bridges decision, I don't know of it, no knowledge. Did it go to the Supreme Court, or was it
That was a Supreme Court decision? Justice Hugo Black wrote the decision.
So the question now is going to be, does the Supreme Court accept a petition for cert to render a decision on an issue that they've already adjudicated on, to rein in the lower court's failure to respect that precedent?
Correct. Especially because there's a bunch of courts that want to start misusing their power to suppress and censor speech. And their new pretext is, if you're a litigant in front of me, that gives me my excuse to control your speech, even if what I'm doing violates the First Amendment.
Very interesting. What do you estimate on your chances of this getting accepted for a hearing?
About 1 in, normally it would be 1 in 10. I think 1 in 3.
Okay. What's the time frame in terms of getting an answer? Is there? I don't know how that works.
It was just filed, so the other side will have a chance to respond. Then he has a chance to reply. So it'll probably be set for conference sometime this summer.